Let's bring in CNN anchor and chief legal analyst Laura Coates. And Laura, that's the first time we have heard the shooter speak when he gave his name. What's the main takeaway here? What just unfolded?
Well, number one, we don't know who his lawyer is going to be. He's been deemed indigent, which means he is unable to afford a counsel of his choosing. And by virtue of the Constitution and the idea of him being able to have counsel, it will be appointed to him. But the judge is asking for somebody under a particular rule who has death penalty experience. That means, of course, we'll have to be well aware of what entails in that sort of thing. But also, you have a very stoic defendant who I was looking to see any emotion that he might be displaying. Hearing that the death penalty may be requested for you is a very monumental, seismic moment. He had no reaction, nodding in essentially understanding alone. But then there was also a protective order that was asked for by the prosecution on behalf of Erica Kirk, the now widow of Charlie Kirk, that entails that there might be an element of fear that she is experiencing, or the thought that she wants no contact either from him or anyone around him that would make her feel more secure. Of course, she is a mother of 2 young children. You understand that. But here you have the charges being read to him. This is not a state where they have a grand jury who you go to and say, listen, grand jurors, here's our evidence of probable cause. Can you then indict this person? They have a preliminary hearing process, which means that a judge will look at the evidence before them and decide whether there is enough probable cause, not beyond a reasonable doubt, to hold this person and find that there is probable belief that this person committed the crime. That's the next court date we're going to hear about. But ultimately, you've got a speaking, essentially, indictment of sorts from the prosecutor earlier today, which laid out so much evidence. It's all allegations, the statements of counsel, not evidence in a court of law. But what can come in a court of law? Yeah. Statement to the defendant, including all these text messages.
Well, let's go over that, because earlier today, prosecutors laid out some of these allegations against the suspected shooter. And here's some of that from just hours ago.
The bullet's trajectory passed closely to several other individuals beside Mr. Kirk, including the questioner who was standing directly in front of Mr. Kirk. Children were visible near Mr. Kirk's stage when he was shot.
The prosecutor, Mr. Gray, there read a trove of text messages between the alleged assassin and his roommate, with whom prosecutors say the alleged assassin, was having a romantic relationship. The suspect told his roommate to delete the messages, hence the charge of witness tampering, presumably. One message from the defendant read, quote, "To be honest, I had hoped to keep this secret till I died of old age. I'm sorry to involve you." The roommate responds, "You weren't the one who did it, right?" With four question marks. And then the defendant says, "I am. I'm sorry." Roommate, "I thought they caught the person?" The defendant, "No, they grabbed some crazy old dude." In another exchange, the roommate asks, "Why?" And Robinson, the defendant, says, "Why did I do it?" Roommate, "Yeah." Robinson, "I had enough of his hatred. Some hate can't be negotiated out." We also learned that the suspect's mother told investigators that her son had become more political and left-leaning over this past year, quote, becoming more pro-gay and trans rights oriented, unquote. Prosecutors also confirmed that the shooter's roommate, with whom he was having a romantic relationship, was in the midst of transitioning from male to female. That is a lot of information from prosecutors in what you call a speaking indictment? Or?
Yes, and of course, interestingly enough, they were still quite conservative in terms of all they may have had. And why? As the prosecutor noted, you want to ensure the constitutional rights of the defendant. You want to make sure that your burden of proof can be met and not tainted in some way by a statement that you're making, or have this idea, which we think of in the common lexicon of an open and shut case. You have to prove every single bit. One thing of note, he is not speaking with the investigators, nor does he have to. It's his right to remain silent. But the words he says can be used in a court of law against him, even if he doesn't take the stand, and even if he does not actually speak to the people who are investigating. Why? Because the statements of the defendant are not even in the category of hearsay, because the theory of hearsay, Jake, is to essentially say, I don't want any statement that comes in that I can't confront my accuser or test the credibility of. I got to address an out-of-court statement from a year ago. No, you have the choice to do so. It's your own words. And there's a part of it. It is prosecutorial gold to have the actual question answered. Why'd you do it? not because you have to prove the motive, but you have an aggravating factor here of the political ideology that has been stated, and of course in front of a child, but because it does give you more of that mountain of evidence you want to prove your case. But the one thing I found so stunning here, normally you think about the identity of the person. How do you know it's him? Well, his own mother identified him.
Yeah.
They addressed that. The mother saw the type of surveillance video that was published for the exact proof of trying to show who the person was and said she called him, questioned him, didn't believe his answer, he was homesick, talked to her husband, also didn't believe. And then the husband said, the father, send me a picture of the gun your grandfather gave you because it sounds like the one that was actually used. He couldn't do it.
Yeah.
This is
Because he'd hidden the gun.
because he'd hidden the gun.
Yeah.
Another charge in this case.